Welcome back, dear students. Today we will learn how to draft a suit for permanent injunction, specific performance, and declaration. Three items will be covered in today's drafting. That is a suit for specific performance of the contract, a declaration, and permanent injunction. Here is a list of books for your reference. You can pick up any one of these books for learning the drafting. So dear students, this suit for specific performance of the contract, declaration, and permanent injunction is to be filed under Specific Relief Act. I'll mention here suit for specific performance of contract, declaration, and permanent injunction. This suit is to be filed under Specific Relief Act. Following suits inter alia can be filed under Specific Relief Act. That is suit for specific performance of the contract, suit for declaration, and suit for permanent injunction. All three are combined in one plaint. So here is an example of suit for permanent injunction along with suit for specific performance of the contract and declaration. Presumed facts are that defendant number 1 agreed with the plaintiff to sell an immovable property, but he failed to execute the sale deed, and meanwhile he sold the same property to another person, defendant number 2, at a higher price. Now plaintiff wants a degree of specific performance of contract in his favor as against the defendants. Plaintiff wants that sale deed done by the defendant number 1 in favor of defendant number 2 should be declared void. Plaintiff also wants that a permanent injunction should be issued against defendant number 2 so that he may not transfer the disputed property in favor of anybody else. Now with these background facts in the mind, we will start drafting this plaint. According to valuation, the name of the court is to be chosen. And here we have chosen the High Court of Delhi at New Delhi as the court where we are going to file this suit. So the opening line of the drafting would be in the High Court of Delhi at New Delhi. In the bracket, you are supposed to mention ordinary original civil jurisdiction, then suit number dash 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 of 1990. Because you do not know the suit number, today you are going to draft this plaint while sitting in your corporate office. Suit number shall be allotted to you only and only when you file this suit in the competent court. A computer generated suit number will be given to you, or the staff of the court will give you the suit number. Now the name of the parties are to be mentioned. You can write down in this fashion also: in the matter of X, son of A, resident of block C, flat number 409, Palam Bihar, New Delhi. He is the plaintiff, versus Y, son of B, resident of 52, Palam Bihar, New Delhi. He is defendant number 1. And Z, son of C, resident of 53, Palam Bihar, New Delhi, is defendant number 2. Now the center heading is suit for specific performance, declaration, and permanent injunction. The plaintiff above named most respectfully sheweth as in the para 1. The plaintiff was looking for land within the proximity of the Palam airport for building a hotel. Para 2. These are the preliminary facts which you are supposed to mention in the plaint. Para 2. That on inquiry, the plaintiff came to know through a registered broker that defendant number 1 is the owner of land bearing number 52, situated in Palam village, and defendant number 1 is willing to sell his said land. The plaintiff therefore approached defendant number 1 for the purpose of negotiating the purchase of said land from him. On 1st July 1989, defendant number 1 entered into a duly registered agreement in writing with the plaintiff for sale of his land measuring 1 acre at the rate of rupees 30 lakh only per acre. And para 4, at the time of execution of the said agreement and in pursuance thereof, the plaintiff paid a sum of rupees 50,000 to the defendant number 1 as earnest money, white check number 24968 dated 1st July 1989, drawn on State Bank of India, Palam Vihar branch, New Delhi. So dear students, here the valuation is 30 lakhs. That's why the suit is drafted and to be filed in the High Court of Delhi at New Delhi. Para 5. In terms of the above said agreement, defendant number 1 was under an obligation to apply and obtain all necessary permissions, clearances from income tax authorities, competent authority under Urban Land Ceiling Act, etc. Defendant number 1 was under a further obligation to make an endeavor to obtain the above said permissions within a period of 3 months from the above said agreement and inform the plaintiff by registered daily post immediately upon obtaining the said permissions. So these were the terms and conditions agreed between the parties. And the balance sale consideration was agreed to be paid by plaintiff to the defendant number 1 within 40 days of receiving the said intimation before sub-registrar at the time of execution of the sale deed. Para 6. The plaintiff continuously followed up the matter with defendant number 1, who kept on informing the plaintiff that necessary permissions have been applied but have not still been granted. On account of inordinate delay and about 6 months having elapsed after the execution of the agreement, the plaintiff got little suspicious about the intentions of defendant number 1, who had also started avoiding the plaintiff on one pretext or the other. Then para 7. In the meantime, the continuous upwards curve in the rise of land prices in and around Delhi registered an abrupt and sharp upward trend, and the price of the land in question increased from rupees 30 lakh per acre to about rupees 50 lakh per acre on account of construction of a community center and shopping complex near the land in question. Defendant number 1 seems to have turned dishonest on account of said escalation of the price of the land in question. The plaintiff therefore once again called upon defendant number 1 to procure the requisite permission and complete the sale in terms of the agreement to sell. However, the defendant number 1 failed to honor the agreement to sell. Para 9. Plaintiff has now come to know that defendant number 1 has sold the land in question to defendant number 2 on 2nd Feb 1990 by its sale deed duly registered before Sub-Registrar Delhi at serial number 786 at pages 345 to 355 in register number 1 for a consideration of rupees 50 lakh. See, this is the reason which has come out now why defendant number 1 is not ready to execute the sale deed in favor of plaintiff, that he has already sold the same plot of land to defendant number 2 for a sum of rupees 50 lakhs. Then para 10, the above mentioned sale deed dated 2nd Feb 1990 executed by defendant number 1 in favor of defendant number 2 is void and not binding on the plaintiff, and is liable to be adjudged as void and as such be cancelled. Para 11. Even if the impugned subsequent sale of the land in suit had not been void, the plaintiff is entitled to obtain sale deed in respect of the land in suit and the possession thereof from defendant number 2, as he can claim title only under defendant number 1, and his title has admittedly arisen subsequently to the contract in writing between defendant number 1 and the plaintiff, particularly because defendant number 2 is not transferee for value and has in any case not paid any amount shown in the sale deed in good faith to defendant number 1. That means in order to defeat the claim of plaintiff, they have created a sham transaction. Defendant number 2 had full knowledge of the agreement between plaintiff and defendant number 1 and has knowingly purchased the land in question from defendant number 1. Para 12. Defendant number 1 has deliberately not performed his part of the contract with the plaintiff out of greed on account of extraordinary escalation in the price of the land in suit. Instead of obtaining the requisite permissions, the defendant number 1 has executed sale deed in favor of defendant number 2, which is absolutely void and not binding on the plaintiff. The impugned sale deed is not for a valuable consideration, inasmuch as the market value of the land in suit was approximately rupees 20 lakh per acre, and it is impossible to believe that land in suit which was agreed to be purchased by the plaintiff at the rate of rupees 30 lakh per acre has been lawfully sold by defendant number 1 at the rate of rupees 50 lakh per acre. So this is not possible. Para 13. That the plaintiff has performed his part of the contract by paying the earnest money of rupees 50,000 to defendant number 1. The agreement to sell does not envisage any other step to be taken by the plaintiff till the receipt of intimation from defendant number 1 about his having received the required permissions. Despite repeated requests and reminders, there was nothing more for the plaintiff to do. So this para says that plaintiff has performed his part of the contract. Whatever was to be done by the plaintiff, he has done it. Now para 14. The plaintiff has throughout been ready and willing to perform this part of the contract. This is compulsory to write down. The plaintiff continued to have from the date of the agreement up to the date the means and resources to pay the balance of sale consideration to defendant number 1 at the time of registration of the sale deed. And plaintiff is still willing to perform his part of the contract. Para 15. That there is no other suitable land available in the area for the purpose of construction of a hotel in the vicinity of Palam Airport. And as such, there is no standard for ascertaining the real or actual damage to the plaintiff in case the agreement in question is not specifically enforced. Para 16 says, the plaintiff is therefore entitled and hereby claims the specific performance of the agreement to sell dated 1st July 1989 and the possession of the suit land from the defendants. The plaintiff is also entitled to have the impugned sale deed cancelled. Para 17. Defendant number 2 is negotiating to sell the land in suit to third party at further higher rates with a view to defeat the claim of the plaintiff. It is therefore necessary in the interest of justice to restrain defendant number 2 from transferring, selling, assigning, gifting, mortgaging, or otherwise alienating the land in suit or any part thereof, or entering into any agreement for any of the said purposes and or parting with possession of any part of the said land or change or effect in any manner, directly or indirectly, the land in suit in any manner themselves or through their agents, servants, representatives or otherwise. So dear students, this paragraph is drafted so that injunction may be issued against defendant number 2 so that he may not further sell the disputed property. Now, para 18. Though the damages for non-performance of the contract in suit cannot be compensated to the plaintiff, however, in view of provisions of Section 22 to 24 of Specific Relief Act and the possibility of relief for the specific performance not being granted for any reason, it is necessary for the plaintiff to claim in the alternative a refund of rupees 50,000 given to defendant number 1 with interest and also damages amounting to difference between the agreed price and the market price of the land in question. The market value of the said land at the time of institution of the suit being about rupees 20 lakh per acre, the plaintiff is claiming the damages in the alternative and strictly without prejudice to his rights and claim for specific performance to the tune of the agreed amount. Now comes the cause of action. The cause of action for the suit for specific performance arose for the first time on 1st July 1989 when the execution of the agreement to sell by the defendant number 1 was done and on payment of earnest money of rupees 50,000 was paid. The cause of action further arose when the defendant number 1 failed to comply with the terms of the said agreement. It finally arose when defendant number 1, in breach of the agreement to sell dated 1st July 1989, executed the impugned sale deed in favor of defendant number 2. And the cause of action for the claim of declaration and adjudging the sale deed of defendant number 1 in favor of defendant number 2 as void and cancelling the said sale deed arose on 2nd February 1990 when the sale deed was executed by defendant number 1 in favor of defendant number 2. Then the cause of action for permanent injunction also arose in April 1990 when defendant number 2 started negotiating for further sale of the land in suit. Para 20, valuation. The valuation of the suit for the purposes of court fee and jurisdiction for the relief of specific performance and in the alternative for damages is rupees 30 lakhs on which ad valorem court fee has been paid. Then the valuation of the suit for the purposes of court fee for the claim of permanent injunction being rupees 200 and the value of the claim for declaration also being rupees 200, additional court fee of rupees 20 each has been paid on the said reliefs. Then para 21 relating to limitation, that the suit is filed well within limitation. 22, the land in question is situated at Delhi and this honorable court therefore has jurisdiction to entertain and try this suit. Now comes the prayer clause. It is therefore most respectfully prayed that this honorable court may be pleased to pass a decree in favor of the plaintiff as against the defendant. So you are asking relief number 1, decree for specific performance of the agreement to sell dated 1st July 1989 and for execution of the sale deed and delivery of actual possession of the land in person to the plaintiff against the payment of balanced sale consideration. Second relief you want is to be drafted like this: a decree for a declaration to the effect that the impugned sale deed dated 2nd February 1990 by defendant number 1 in favor of defendant number 2 be declared as void and not binding upon the plaintiff, and calling upon the original sale deed and judging the same as void as against the plaintiff and otherwise cancelling the same. Third relief you want is a decree for permanent injunction in favor of plaintiff as against defendant number 2, restraining him from transferring, conveying, alienating, or assigning any part of the land in suit or from entering into any agreement for any of the aforesaid purposes, and from changing the status quo of the land or parting with possession thereof, either directly or indirectly or in any manner whatsoever. So this is the third relief which you have cleared. Fourth relief is to be drafted in alternative. You want that in the alternative, in case of refusal by the court to grant specific performance for any compelling reason, grant a decree in favor of the plaintiff and against the defendant number one for a sum of rupees 30 lakh with interest from the date of institution of the suit till the date of the decree, and future interest from the date of the decree till realization at the rate of 18% per annum or at such other rate as the court may deem fit, proper. And number five, the cost of the suit be also awarded in favor of the plaintiff as against the defendant. As usual, the signatures of the plaintiff are required on this plaint, and since this plaint is drafted by some advocate, so you will write down through advocate so and so. His name and signatures are also required. Then place of drafting is Delhi. Date of filing is 1st June 1990. Now the lastly, verification is required. Where you have verified this claim? At Delhi. So verified at Delhi on this first day of June 1990 that the contents of para 1 to 18 are true to my knowledge, and those of para 19 to 22 are true on information received and believed to be true, and the last para is the humble prayer to this honorable court. And after verification, once again, plaintiff will sign this claim. So dear students, this is how we have learned the drafting of a plaint for specific performance of the contract, then declaration of sale deed as void, and further a decree for permanent injunction so that defendant may not transfer this land again to someone else. So thank you very much, dear students. God bless all of you.